Welcome to our module covering terminating individual employees. This is going to be contrasted with situations where you may be involved in a reduction in force that's affecting lots of employees. And so there are different legal issues that relate to both of these categories. There's overlap, but there's also some separation here. So let's go ahead and begin. We've got 5 discrete topics that we'll be covering in this module. The first is sometimes there's an issue about whether we've actually dismissed somebody or not. The employer may say, no, that employee abandoned his job or he or she resigned. The employee may say, no, this is a situation of constructive discharge. This is a topic we've talked about in the past, but we're going to revisit here to kind of refresh on it. The next topic that we'll talk about is also one that we've talked about many times before, and that is the topic of employment at will. It's just so important that I'm going to revisit it briefly here because obviously that is the usual relationship that employees and employers have in the United States. And so that's certainly important for the employer to consider before it makes a decision about whether to continue an employment relationship or to end it. And then we have what are the reasons that you cannot dismiss somebody even if he or she is employed at will? So we'll go through many of those bases. This won't be an exhaustive look, but it'll cover the most important categories. Next, we'll discuss the topic of just cause/due process and how that interacts with employment at will and what are the takeaways for the employer as it navigates through the process of deciding whether to terminate or not. Our final topic for this module assumes that we have decided to terminate the particular employee. And once a decision is made, it needs to be implemented. And the implementation is almost as important as the decision. Many times an employer can be well within its rights to dismiss somebody, but the way that it handles the dismissal is so poor, is so unkind and unprofessional that the way that it's handled can actually create liability, even if there wouldn't have been liability otherwise. In addition, a poorly handled termination can suggest motivations that may never have been in play, but they may suggest motivations to a jury, and that can create the appearance of liability, even though perhaps there is no literal liability. So let's begin with our topics. And again, our first topic is constructive discharge. Obviously, when we talk about dismissals, it's easy when we're looking at it from the employer perspective, and that's what we do primarily in this course because the most employment law paralegals and attorneys are going to be working on the defense side. That's just the nature of the beast. Employees don't have to make decisions about legal compliance. The employer is the one that has to make those decisions. So the vast majority of legal professionals work on the employer side. There are some plaintiffs' attorneys who do employment law, and of course, they typically get involved in the situation after the employee is dismissed. But it's still important for them to kind of do a postmortem. They need to know what the standards are to see if the former employer of their client complied with those standards. Um, but most of our work is going to be working for the employer. And that makes sense because the employer is the one that makes the decision. If you happen to be inclined to look at the world more from the plaintiff's perspective, keep in mind that the legal professional can have a very profound impact upon the employer. In fact, I would say if you're interested in workplace justice, where the real action is, where the real opportunity to make a difference is working for the employer. Because after all, a plaintiff side attorney, all he or she can do is come in and clean up a bad situation after the fact. But the employer's attorney and paralegal can actually avoid that bad decision from the beginning and can help create a culture where the law is complied with and where best practices exist. You may think, well, that's pie in the sky. That's not how things really happen. Actually, it is how things really happen. In many corporations, lawyers and paralegals have a very profound impact upon the employment decisions made. Certainly when I was at JCPenney, very few employment decisions were made other than very new employees where somebody in the legal department wasn't involved to some extent. And usually the legal department person needed to approve the employment decision. And of course, the legal department was very much involved in establishing procedures and policies with respect to that. So, if you are interested in creating a more just and equitable workplace, I would strongly encourage you to think about working for employers, because in that situation, you can really help employers avoid making poor decisions. In that spirit, I think it's always important to keep in mind that a job, when you're working on the employer side, you're focusing on solving the employer's problem. That's what you should be doing because that's the nature of your job. But it's always a good idea to keep in mind that this is somebody's livelihood. This person has a mortgage or a rent to pay. He or she oftentimes has a spouse, maybe minor children at home. And so the implications of the decision can be very, very significant for this employee. And it's always important to have that, not in the first of your mind, because obviously if you work for the employer, the employee is not your client, but to be aware of that impact. Certainly the jury will be aware of that impact. Now flipping to the client side, your employer is also stressed by this situation. And when I say the employer, I'm not talking about the legal abstraction, the corporation, the partnership, the LLC, whatever your client is. I'm really talking about the manager. Um, Managers, there's a few jerks out there. There's more than a few probably, but most managers don't like to fire people. It's not fun. And even if the manager is not too bent out of shape about terminating somebody, uh, it's a huge workplace inconvenience. You're going to have to look for a replacement. You're going to have to train the replacement. You're going to have to deal with some workplace upheaval when the other employees find out about it. You may have to deal with an unemployment claim or a claim of discrimination. There's stress there. There's extra work there. And so it's important to navigate and to lead your client in navigating through these situations to reduce the stress and to reduce the danger. And that the strategies that we'll be talking about here will hopefully accomplish those goals. Now, there is no termination that is completely without risk, and there are obviously situations that you do need to terminate an employee. So there's going to be a balance that happens. And ultimately, this is a decision that the employer needs to make, that the client needs to make. You, the legal professional, give information, and if you're the attorney, legal advice to the client to help it navigate through this situation. But you're focusing upon the law. The employer also has the concern of getting the business done, making a profit, making sure that employee morale remains positive, all of those issues. And so the legal part of the equation is really, really important and should be treated as if it were really, really important. But it's not the only piece of the puzzle. Of course, at the end of the day, why we care about all this topic from the client's perspective is that terminations are where the game is played in employment discrimination, which of course is the main topic of this course. Yes, there are cases of employees filing lawsuits when they weren't hired or when they were demoted or when they weren't promoted to a position. But 90+% of the action in these particular claims are going to arise in termination situations. So you can take a little bit of risk sometimes in the decision about who to hire or who to promote. But when you're going with terminations, it's a much more dangerous area. in part because you're much more likely to get a claim, but also because there's significant money at stake. A person who goes from being employed to not being employed is looking to lose tens of thousands, maybe even hundreds of thousands of dollars before he or she is reemployed. And that potentially can be an expense for the employer that the employer will have to bear if the court does not agree with the decision that the employer made. Okay, so obviously the issues that can come up when you're terminating an employee is going to depend in part upon what type of employer you are. If you are a public sector employer, say the state government or the federal government, um, there are going to be different rules and different protections for the employees. These are topics that we've talked about in the past. I'm not going to go through all of the ins and outs of those at this particular time, but just be aware that they do exist. Also, there will be some legal differences when the employee is part of a bargaining unit that a union is the representative of. Then, of course, the main category where the vast majority of workers exist are going to be in the private sector. And that's what we're going to be talking about in this lecture, were situations where the employer is the private sector and the employees are non-union. As we've talked about in the past, this relationship is going to be employment at will almost always, unless it's a very high-ranking executive within the company. As we talk, and we won't talk much about it, but as we talk about the unionized and public sector employees, we're much more likely going to be talking about that just cause or due process analysis. We'll be talking about that within the context of employment at will as well, but those terms are more closely associated with the unionized or public sector situations. As I said before, when we talk about a downsizing or right sizing or reduction in force or whatever euphemism you want to use for a mass layoff, some of the legal issues will be different in those situations, just kind of alerting you to that. And we won't talk about them in this particular presentation. So let's talk about constructive discharge. We've talked about this in the past, so this should sound pretty familiar to you. This happens when there's a disagreement about whether a particular employee has been dismissed or not. A situation could arise where an employee is demoted, and maybe demoted in a humiliating way, being asked to do work several steps below where he or she was previously. Perhaps he or she is reporting to somebody who he or she used to manage. And those types of situations, and that's just one example of constructive discharge, but it's a fairly common one, can be intensely uncomfortable for the employee. I think we can all imagine how difficult that would be. It's also, frankly, often difficult for everybody else in the work unit. And sometimes these changes happen because the employer wants to get this employee out of the workplace, but doesn't actually want to dismiss him or her. Perhaps the employer feels that he or she doesn't have enough facts to support a dismissal. Or perhaps someone within the organization is protecting that particular employee from dismissal. And so the employer is trying to do an in run and motivate the employee to quit on his or her own by making the situation very, very uncomfortable. If if that is really what's going on in the situation, then it's very possible that the employee is still going to be able to claim that he or she was discharged by saying that it was a constructive discharge. We've had this term before, and so you probably already have it in your Quizlet, but if not, yeah, please consider adding it. Here's a definition for constructive discharge. It's a termination when an employer creates an intolerable working conditions with the intention of forcing an employee to quit. And a reasonable person would have felt compelled to quit under those circumstances. There's a lot to unpack in this. The first is the word intolerable. It's not unpleasant. It's not uncomfortable. It's not less than ideal. It's intolerable. So this is a very high standard. a situation where, it's not very comfortable. It's just not what you'd ideally want. That has nothing to do with constructive discharge. We're talking really, really bad stuff. Next thing is it has to be done with the intention of motivating or forcing the employee to quit. So if a business is going through some difficult times and it is reducing people's pay, or it's changing work assignments, or giving people additional work assignments, but those changes are motivated because of the economic downturn, that's not constructive discharge. Even if the employee thinks the working conditions are truly intolerable, that's not enough. You also have to have this intention to force the employee out. And so you need to have both of these elements. It's difficult to prove intention unless, of course, you have a smoking gun. And sometimes you do have it with emails back and forth that you get in the discovery process. But if you don't have something like that, you're really going to require the jury to find intention given the totality of the circumstances. And merely having intolerable working conditions doesn't get you to the finish line unless they're very, very shocking. So keep in mind that these are two requirements. Um, and the standard for, and I guess a third requirement is going to be the reasonable person would have felt to be compelled to quit under the circumstances. So we're not focusing on this particular employee. We're not saying, well, this particular employee felt compelled to quit. Obviously, he felt compelled to quit because he did quit. But we're talking about a reasonable person. And again, a reasonable person is that objective standard. We're not thinking about a particular person. I mean, we all have our own quirks and idiosyncrasies, and there would be in things I would consider intolerable in a working environment that you'd say, suck it up, buttercup. And there might be things you think of as intolerable in a working environment that I'd be like, big deal, get over yourself. Um, so we're not looking at a person's individual quirks or the particular employee's individual quirks. What we're thinking about then is kind of the reasonable person, kind of the average person. Somebody of average intelligence, average experience, average education, average levels of sensitivity. Imagine for a second that a person, let's say, I'll say an Amish person, goes to work for a business, and this is a very sheltered person who hasn't been exposed to profanity or dirty jokes or uh, uh, you know Playboy type pictures or things along those lines. We'll say her name is Susan. Anyway, she enters the work environment here, and it's a very sexualized work environment. There's lots of swearing, there's lots of dirty jokes, there's lots of uh, pictures of scantily clad people, or maybe not clad at all people. And she genuinely finds it intolerable. She cannot stand it at all. She is so uncomfortable all of the time. She just can't possibly consider staying here. And she knows that her boss doesn't like her, doesn't think she's fitting in or doing her fair share of the work. And so she knows her boss wants her out of here. And she's complained about the sexually charged atmosphere, and he's done nothing about it. Well, and so she quits. Well, the test won't be whether she genuinely had all of those feelings. The test will be, would a reasonable person have felt so uncomfortable that they would have seen the only option to be quitting. And so the fact that she's a very conservative person, that she's Amish, that she's led a sheltered life, none of that is going to fit into the analysis of reasonable personhood. A reasonable person, I'm not saying that the Amish aren't reasonable people. I don't mean it in that sense, but the average person in a culture isn't Amish. The average person in the culture isn't especially sheltered. Probably the average person in the culture sometimes even maybe swears. And so you have to keep in mind that we're not going to look at the particular characteristics of the person who is claiming constructive discharge, but kind of an average person. And as a practical matter, what ends up happening is that the jurors, of course, they each think of themselves as a reasonable or a reasonable person. So they kind of put themselves into that situation. And they think to themselves, would I have been felt compelled to quit under these circumstances? And so that can be kind of a meaningful look at how you arrive at constructive discharge. You can see here that if you're working on the plaintiff side, you're probably thinking to yourself, that's a tough hurdle to overcome. And you're probably thinking, well, I'm not going to accept a lot of cases from potential clients with a constructive discharge theory. I actually want my potential clients to have been discharged because I don't want to have to deal. This is an extra hurdle that seems pretty difficult. Well, you're right to think that way. Most plaintiffs' attorneys aren't going to be interested in constructive discharge case unless the facts truly are extreme. And if a potential client goes to see an attorney before he or she has actually quit, the attorney's going to say, stick with it, let them fire you. That's a much better case to take than a constructive discharge case. But it doesn't mean that you can't win constructive discharge cases. It's just adding a significant hurdle to the plaintiff's case. Okay, now we're going to talk about employment at will as well as the exceptions relating to employment at will. So employment at will is a legal standard that exists in the United States for everybody who wasn't part of a union facility and or didn't have a separate employment contract until the 1930s. So before the 1930s, there really was no concept of wrongful termination. The employee could leave at any time. The employer could leave at any time or could end the employment relationship at any time. There was no idea that the employer kind of owed it to the employee to maintain the employment relationship beyond what the employer felt was in its interests. Our current standard is still employment at will, but it's employment at will with some few exceptions. And again, if you think about it, if this is the employment at will world, the exceptions are just these small little things. Oh, you can't fire somebody for that, and you can't fire somebody for this, and you can't fire somebody for this, and oh, I guess you can't fire somebody for this. But the vast majority of reasons you can fire somebody aren't covered. They aren't exceptions. Exceptions are rare. The usual rule is, yep, if the employer's not happy with the situation, the employer can end it. And similarly, the employee can end it if the employee isn't happy. So that remains the usual expectation. An employer, and this is again the rule, an employer may terminate an employee for any reason except prohibited reasons developed by statute or common law since 1937. Okay, let's just consider the due process situation, just cause. And again, these are kind of synonyms for each other. So just cause is saying, when you have the standard in effect, it's saying, well, the employer has to have just cause before it can dismiss the employee. In other words, the employer has to use due process before it can dismiss an employee. Now, many of us think about due process as something that the court system provides for folks, especially in a criminal context, but also in a civil context. So, for example, in the criminal context, we think about due process being the right to confront your witnesses, the right to have an attorney present, the right to know the charges against you, the right to not have to testify against oneself. All those we would consider the right to a jury. All those we'd consider due process type protections. They are process elements that protect the criminal defendant and make sure that the process is fair, reasonable. And so we call that due process in the criminal situation. But we also use this term in the employment law situation, largely to be a synonym for just cause. And again, we think about these terms as being in contrast to employment at will. We'll see later that they're not completely in contrast, but but there is some level of contrast. So under this standard, whichever term you want to use for it, just cause is probably the more common term, employers bear the burden of proving that the termination was proper and based upon good and lawful reasons. So it is on the employer to show, hey, Sally was perpetually late to work. That's why I fired her. But let's say the the boss is having a bad day, and Joe comes into his office and asks one too many questions. And the boss, gets angry and says, Joe, you're out of here. I'm sick of these dumb questions. Leave the facility. I'm firing you. That probably is okay under employment at will, unless, of course, the boss treated Joe that way because Joe's African American, or Joe's a man, or Joe's a Presbyterian, or whatever. But that type of termination would not fly under a just cause, a type of evaluation. About 20% of the workplace in the United States is under a just cause standard. It's going to be significantly lower than this in Texas. I would say 10% maybe. And most of those are going to be public sector employees. And even some public sector employees are employed at will. So it's not a major part of the workforce in Texas. Okay, so let's talk about when we're dealing with an at-will employee, let's talk about some of the reasons that are unlawful for an employer to dismiss. And we can find these reasons, some of them under the Constitution, although that's a pretty rare area for private sector employment. We'll find some under statute, either a state statute or a federal statute. And we'll find some in the common law. Again, this is judge-made law. So we won't find this in a statute in this case. We won't find it in the code. We'll find this in court decisions. And the two main areas that we see common law protections are going to be in contract law and tort law. So here's a neat breakdown. If you may want to remember slide 12 here, because this one gives you a really nice summary of the major areas that you can see employment protection for employees. And this includes both public sector and private sector employees. So we can see that public sector, First Amendment, if I speak out, maybe I write a letter to the editor of the local newspaper, and I work for the state government, the federal government, my boss can't fire me just because I say something that disagrees with what he thinks about a particular topic. The Fifth and Fourth Amendment have to do with some due process protections. Again, public sector employees can have a property interest in their position, and so you can't take away somebody's property without due process. And there can be issues in some state constitutions as well. This isn't likely to be a fertile ground in Texas, though. So again, we're really talking about public sector when we talk about constitutional issues. Statutory issues, again, we'll see laws relating to civil service and tenure laws. This would primarily relate to school teachers. These, again, are going to be relating to public sector employees. Then we have the anti-discrimination laws, Title VII, the Americans with Disabilities Act, the Age Discrimination and Employment Act, the Equal Protection Act. Equal Pay Act. Sorry, I was talking about the environmental law there, silly. Environmental Protection Act, I guess, was thinking about conflating the two. This is by far the most important of all of these in terms of the actual litigation that we see. And this, of course, applies to both public sector and private sector employees. Then we have the Family and Medical Leave Act, the National Labor Relations Act. This largely applies to union situations. Either a union exists or a union is trying to organize a particular workforce. But as we talked about, concerted activity Protections apply to employees even when there is no union activity at all. So the NLRA does sometimes apply to completely union-free situations. Then we have the Family and Medical Leave Act. We have protections under OSHA and ERISA. Here I'm thinking about 510 for ERISA. We have whistleblower protection laws, and of course, there are whistleblower protection aspects to all of these laws as well. And then there are separate statutes that just deal with whistleblower protection. We have civic duty laws. We'll look at one of these in a few minutes. USERRA is another one. That's a federal law. Off-duty conduct laws. Many states, not many, several states protect employees who use tobacco products or use alcohol or other substances when they are off duty. Texas does not have those. And then Montana is the one state that is not technically a state that is employment at will. I say that because um, even though Montana describes itself as not an employment at will jurisdiction, as a practical matter, it's really not that different from what we have in the other 49 states. And in fact, I would say it's much easier to fire somebody in Montana, say, than it is in California, even though California technically is an employment at will state. The system that they have in Montana is a just cause system, but it really ends up being pretty much just a more generous unemployment benefit. And so it's a, yeah, I'm not going to spend a lot of time talking about it because obviously we're not in Montana. But if you see in the literature that Montana is not employment at will, that's technically true, but I think it's sometimes publishers make more of a big deal about it than is really reasonable. Now we're going to talk about common law. And of course, we have contract here. We can have individual contracts. This oftentimes happens when we're looking at an executive in a corporation or some other highly paid person, basketball players, football players, those types of individuals. Then, of course, we have labor agreements, and these are not individual. These are going to be between everybody in a bargaining unit and the employer. You can have situations of implied contract. We've talked about this a little bit, especially in California, but there are other jurisdictions where it can work. Sometimes the contents of an employee handbook can be considered an implied or sometimes even express contract. Implied contract arguments are not that strong in Texas, but certainly the law evolves, and because this is the common law, there is that potential for over time it to kind of be broader. And so, who knows what we'll be talking about in 10 or 15 years. Then we have the covenant of good faith and fair dealing. That is part of every single employment contract. And even when we don't have an express contract, the at-will nature of the agreement is a contract. It's an at-will contract. And so it does have a covenant of good faith and fair dealing associated with it. But that covenant doesn't somehow trump the at-willness, so to speak, of the agreement. It's not going to change that. It's just going to mean that given the fact it's at will, and without changing the fact that it's at will, both the employer and the employee have to act in good faith and fair dealing. So, for an example, an employer can't lie to the employee and say, oh, or shouldn't lie to an employee and say, oh, I would never end this employment relationship. Um, you're such an awesome employee. No matter what happens, you can count on a job here. That's not acting in good faith or dealing fairly with the employee. Especially if that is something that the employer says on a regular basis, and especially if they've written it down. Under those circumstances, especially in California, the employee might be able to say that that somehow or another is going to trump the at-will status. I wouldn't make that argument in Texas. I don't think it's one that will likely go very far, again, unless you have a written document to that effect, especially if it were individualized to the employee. Spoken words probably aren't going to trump at-will status, especially if the client has been careful about communicating that at-will status to the employee. Then promissory estoppel. This is when an employer has made promises. You can see promissory here. And based upon those promises, the employee has done something to the employee's detriment. And now the employer doesn't want to fulfill his promises. And sometimes courts will say, well, we're going to just pretend there's a real contract here. Let me give you an example. Let's say that Bob is applying for a job to work for Groover Industries. And I interview Bob and I actually extend him a job offer. I say, Bob, I want to hire you for $100,000 a year. I'd like for you to start next Monday. By the way, I need you to relocate to Houston. And so I'll see you there Monday morning in the office in Houston. Well, Bob accepts the job offer. Thank you. Thank you. I'm very excited. And accepts the job offer and immediately goes to his apartment complex, cancels his lease. He has to pay $1,000 to get out of his lease. He hires some people, pays them $500 to load a moving van or a U-Haul. And Bob, of course, rents the U-Haul. Bob drives down to Houston. He rents an apartment. He has to pay an unusually high rent because it's such last minute. And he starts and he shows up Monday morning. And so I see him on Monday morning and I say, hey, Bob, what you doing here? I go, well, this is my first day here. I'm excited to be here. I'm like, oh, Bob, that was just a joke. I wasn't really extending a job to you. I don't really like you and I want you to go away now. But but you told me that I had a job. Oh, well, okay. You were my at-will employee up until now. Now I quit. Now I fire you. So yeah, so I did employ you for 5 minutes. The 5 minutes you've been here, yeah, you were employed. I'll pay you, $10 for your time or whatever the amount is. But the Bob says, but I broke my lease. That cost me $1,000. I had to pay somebody to pack my stuff. That cost $500. I had to rent the U-Haul and drive down here. That costs, $300. I had to uh, pay an exorbitant amount of rent. That's cost me another $1,000. I'm out like $3,000. That's not right of you to tell me I don't have a job. That would be a scenario where promissory estoppel may be a legitimate avenue. But you almost need facts that extreme for it to work. Maybe not that extreme, but you definitely do need facts. And what's not going to happen, even if you're successful in making a promissory estoppel argument, what's not going to happen is the employer isn't going to be required to continue the employment relationship. All the employer is going to be required to do in the best case scenario for the employee is pay those costs that the employee has borne, the costs incidental to his believing the promise that the employer gave and then retracted. Tort law is another area where you can see claims for wrongful discharge. We can see under the public policy exception. We'll be looking at Sabine Pilot one more time in a few minutes to kind of cover that. You can also have intentional interference with contractual relationship. What we usually call that in Texas is intentional interference with a business relationship. That's the kind of name that we use in Texas for that particular tort. We can also have infliction of emotional distress. Some jurisdictions recognize negligent infliction of emotional distress. Texas is not one of them. So our tort in this area is intentional infliction of emotional distress. Then, of course, you can have defamation, and that, of course, arises in two situations. One, it can be slander, which is spoken defamation, and the other can be libel, which is written or at least recorded defamation. Then we can have the privacy torts. We talked about those 4 torts in a previous presentation, and the idea of false imprisonment. All of those things can arise in a discharge situation from time to time. You can see that these torts, especially these, are really about how you commit or conduct the termination discussion. So this has to do with process more than what the decision actually is. And we'll talk about the process in our last section in this unit. Under the implied contract exception to employment at will, the right of employers to terminate may be limited. So statements made by an employer can give rise to an implied contract, as I already said. This is an argument that is won in California and other jurisdictions. It has not won in Texas yet, but it's possible there could be an evolution of the law. Certainly from a common law standard, given the current composition of our Texas Supreme Court, I think that would be an unlikely development. But of course, they're elected, and at some point, there may be other people on the Texas Supreme Court that approach these issues in a different way. And at that time, obviously, the common law could change. So here are some criteria that are used for determining the existence of an implied contract. I'm not going to go through these except just to make you aware of them because, as I said before, this is not likely to be a winning argument in Texas. But these are the things in jurisdictions that might be open to an implied contract theory that would be relevant. It's important to note that it's not so much that you have to have all of these elements or you have to have most of these elements. It's really not kind of like a scales where, oh, you have 3 on this side and you have 4 on this side. It's really how strong they are. So for example, if you have really clear and specific promises that have been made by the employer, lots of witnesses to them, they're just really indisputable at this point, that in and of itself might be enough to tip the balance. On the other hand, if the promise wasn't that specific, if there isn't a lot of evidence that the promise existed, you're going to need to have some additional stuff here to balance it out. So here are a couple examples that I wanted to highlight. Sometimes employee handbooks will have lots of, employee handbooks are a very let's see how to say this. Let me go back in time. If we were in the 70s, 80s, 90s, an employer would almost certainly have some kind of a large employer would almost certainly have a type of handbook that it would distribute to the employees, and the employees would have it, and it was kind of uh, it performed lots of functions. It provided certain legal notices to employees that the employer was required to provide or thought would be advantageous to provide. It also gave employees some information about the culture of the company, and many times would talk about the circumstances under which a termination could happen. Some handbooks were pretty brief. Some handbooks were hundreds of pages long. With the advent of the internet, the handbooks became less and less common, and they oftentimes were just online. And instead of being a single document, like you would have if you had a book or a pamphlet, uh, they were oftentimes kind of broken up. And so an employee wouldn't have just one online location for the employee handbook, but some of that information might be, in on this website over here, or it might be over here in this website, or this link would take you here. And so it ceased to become really a single handbook. This might talk about what circumstances you can be dismissed. This might talk about corporate culture. This might provide legal notices of various types, for example. So the employee handbook has to some extent become a dated tool, or at least less commonly used, especially in the private sector. But again, some employers still do have the handbook, or at least they have the pieces of the handbook spread out in various locations. And sometimes employers will have very detailed descriptions of what employee might do to result in his or her dismissal. If the list is long and seems to be exhaustive, and especially if it doesn't have some kind of catch-all at the end, like, and other reasons, or the employer reserves the right to dismiss for other reasons as well, or there's some reminder in the list that this employee is employed at will. If you're missing those things, then it may look to the employee like, oh, these are all of the reasons I can be dismissed. So if I did something or didn't do something that's not on this list, I can't be discharged for it. That's the logic. And some courts have found that to be a powerful argument. Again, don't think that's likely to get a lot of traction in Texas, but in other jurisdictions, I'm thinking South Carolina especially, has found that type of idea to be appealing. The employer did not communicate to employees a change to a less protective policy. So let's say that the employer did have this handbook in effect, and maybe the handbook even included language that says, these are the only reasons you can get dismissed here. And then the employer decided, oh, we don't like that policy anymore. So we're going to change this online policy, but we're not going to make a big fuss about it. We're not going to go to employees and say, okay, we're having a meeting. We're going to tell you how we've changed this website. So the only employees who noticed the change were the ones who happened to visit that website. But all the other employees who maybe had visited that website early in their employment assumed that the rules of the road were the same. In that situation, even though in some sense the contract changed, the implied contract that with the more generous protection might still be in effect. Then another thing for the handbook is there may not be any effective disclaimer in the handbook. Some jurisdictions, I'm thinking Illinois, has a very specific rule about how the disclaimer has to be presented in the handbook in order for it to function. And here I'm talking about an at-will disclaimer or language that states this isn't creating a contract of employment. Some states require that the font be of a certain size, that it be in a certain location in the handbook, that it be in bold print, for example, those types of requirements. And so it's always important, especially if you're dealing with a client that is in multiple states, to make sure that you are up to speed with all of those jurisdictions because they may have one of these requirements and you want to make sure that your disclaimer satisfies those requirements. Speaking of disclaimers, let me just show you an example. This disclaimer I pulled from a major law firm's website, Davis Wright, and that is, this is a kind of a sample disclaimer that it is recommending. So this would be a section in the handbook. Sometimes people put this at the beginning, sometimes people put this at the end, but this is how it might read. The purpose of this employee handbook is to bring together in a convenient place a summary of some of the policies that affect employees. Employees should read this handbook and become familiar with its content. Employees should be comfortable referring to the handbook whenever a question regarding employment with the company arises. However, the handbook will not answer all the questions employees may have about company policies or benefits. If the handbook does not answer the question, employees should contact their supervisor or human resources for assistance. The handbook revokes and supersedes any prior summaries or statements of employment practices and procedures. The company expects to revise and update this handbook from time to time. The company will advise employees of changes or additions or deletions in policies and procedures covered in this handbook by circulating such changes or additions or deletions either in writing or electronically. This handbook is not a contract of employment. It does not promise or guarantee any particular benefit or particular action. As explained in this handbook, all employment with the company is at will, which means the company or the employee may terminate the employment at any time with or without cause, with or without notice. In addition, employees may be demoted, job duties may be changed, or benefits altered at any time with or without cause and with or without notice. No one in the company has the authority to enter into any agreement for employment for a specified period of time or to make any representations that are inconsistent with the at-will status. Now, this is one way of phrasing it. Most are going to choose the alternative wording because most companies are going to have a handful of people that do have written contracts. And if you have this language, then you can't have written contracts, obviously. So what you do is you have this language instead, but you actually give the title of the person who is going to have that authority. And typically, it's who's ever head of the human resources function. You have to be careful here, though, because Sometimes organizations will change the title of people. So maybe the title is currently a senior vice president in charge of human resources, but later on it becomes human resources senior vice president. Well, with the change in title, you've now, there's a little bit of a disconnect between the title you're using here and the title that actually is used in your facility. So want to think that through carefully. And what you don't want to do is you don't, of course, want to use a person's name because that person may leave the company and then you can't, until you've made a change to this policy, you can't enter into any more employment contracts. So this is an example of a disclaimer. You can see it's not warm and fuzzy. It's designed to satisfy legal requirements. It doesn't necessarily make people feel particularly happy inside. So most of the time, employers are going to hide this in the back of the handbook, figuring that employees really aren't probably going to read it, or at least they're going to have read the warm and fuzzy stuff before they get to the disclaimer. But again, in states that do require certain aspects of the disclaimer, it may be necessary that this be in the front at the very beginning. Let's go back to our PowerPoint. Many courts permit employers to unilaterally make changes to employee handbooks containing implied covenants or contracts, provided that the employee has reasonable notice, but some courts do require more. Again, Texas courts are unlikely to find an employment contract having arisen out of an employee handbook, but if it were, it certainly would allow the employer to change the handbook whenever it wanted to. But as you can, if you've taken contracts, you know that one side can't change a contract on its own unilaterally. There needs to be some consideration or some benefit that the person who wants to change the contract is extending to the person who is agreeing to the change in contract in order for the change to go into effect. And so if you're in a state that makes that requirement, the employer would have to do something more than just change the wording in the employee handbook in order to change the policies for current employees. Again, not the rule in Texas, but just be aware that that can be necessary. Okay, so let's consider a disclaimer here. Let's see, we have a definition. A disclaimer is a written statement in employment documents that deny that those statements create any contractual rights binding on the employer. And this is very common. Usually, performance appraisals will have this language on it. Performance improvement plans will have this language on it. It's pretty common for them to be in offer letters, on applications. Pretty much almost any document that is HRE is going to have a disclaimer, or at least potentially can have a disclaimer. Again, the reasons that you might not want to have a disclaimer are that they aren't warm and fuzzy things to have. And so the perception can be that, oh, there's an adversarial relationship here, when of course that's not what the employer ideally wants. And so, the legal department is pushing, oh, let's always put a disclaimer. Let's always put a disclaimer. The HR department may be taking a position of, that's not creating the mood we want for this particular document. And so there's a kind of a tug of war that happens. So to maintain employment at will, employers should use disclaimers in employee handbooks and other employment documents. And again, the example language is what I just showed you a few minutes ago. Employers should communicate disclaimers to employees. Again, that would be, for example, to the handbook. Also, they can be through, once a year, screens that come up on people's computers or emails that get pushed out. Ideally, the employee should acknowledge receipt of the disclaimer. It can be in writing, or it can be just a quick acknowledgement if it pops up on the computer. That can be evidence that the employee has seen that policy and seen the disclaimer. Disclaimers have to be carefully worded. They have to be worded to make sure they comply with state law. If a particular employer is in more than one state, it needs to work in all those states. And so it's a artful process to come up with a disclaimer that communicates what it needs to, but isn't too harsh to the ears of the employee. If it's worded carefully, though, it's likely that a disclaimer is going to be very effective in Texas, and it'll be effective almost anywhere. There would be a few jurisdictions where disclaimers aren't as effective. California obviously comes to mind, but probably 40 out of the 50 states, a well-written disclaimer is going to be a very effective way of reducing the employer's risk. We've already talked about the covenant of good faith and fair dealings. I don't really have a definition here that I'm providing. I guess it's kind of implied. Let's see if we can find a definition here. I'm just going to go to Law Dictionary. Yeah, this is a good definition. So when you're doing your Quizlet, just go to dictionary.law.com and type in covenant of good faith and fair dealing. We also have promissory estoppel. Yeah, promissory, this is also a good definition. So those are two that you can use for your Quizlet. And be sure to add these if you don't already have them in your Quizlet. We've already kind of talked about them, so I'm going to move on. Intentional interference with a contractual business relationship is a tort. So be sure to flag this. And here is the definition to use for this one. It occurs when intentional improper interference causes a third party to breach its contract with the plaintiff or to not enter into a contractual relationship with a plaintiff. So imagine that I want to, I had an employee, Bob, and he left my employment, and I'm very mad that he left. I feel like he he really messed up my business given the timing that he left. We were about to complete that big project. We were right in the middle of it. He was essential to it. He left us, and it caused a lot of financial loss for the company. So I decide that I want to get even with him. And so I go to his current employer, the employer that he left me for, and tell the employer, what Bob did to us. He didn't give us notice. He uh, uh, intentionally left right at that most vulnerable time. And I say, if he treated us this way, he'll treat you that way when you're in a pickle. And so I would recommend you go ahead, because you're not to that point yet with him where he's essential to your organization. I'd recommend you go ahead and fire him. And in that situation, I may not have told a single lie. Everything I said may have been absolutely true. But my intention in telling that in this particular case is to harm Bob. It's not to help my buddy. It's not to help my friend, because let's say he wasn't my friend. In that situation, it's possible that I am guilty of the tort of intentional interference with a contractual relationship. Cases where an employer blacklists a former employee to prevent him or her from obtaining other employment. So it used to be the case. Now it's no longer nearly as common, but it used to be the case that employers in a particular industry would have a list of people who were pretty much unhireable in that industry, and it was literally called a blacklist. It had nothing to do with race. It just had to do with the fact these people you're not going to hire. Don't hire these people. And competitors, would share this list with each other. And so, imagine an employee at Coke who was fired. Well, Pepsi would not hire him, and Dr. Pepper would not hire him because this name would be on this blacklist. Um, that type of action is no longer lawful, and so it doesn't mean it never happens, but it's much less common to happen in that situation. Another situation where it can arise is when one employer raids another employer and takes the employees. Imagine for a second that when Bob left my employee, it wasn't just Bob, it was my whole team. There were 7 employees all working on this crucial project. And Smith Industries hired them all away. And Smith Industries didn't hire them because, oh, just coincidentally, Smith Industries needed 7 people with those skills. No, Smith Industries was actually intending to sabotage my business. They knew I needed those 7 workers at this particular moment in time, and that's why they hired them to maybe destroy my business and therefore cause Smith Industries to have one fewer competitor, which would be maybe helpful for it and his business. So that would be an example of a raid situation. It's not unlawful for Smith Industries to interview my employees and even to interview more than one and to offer more than one employee a job. But when it's intended not to improve Smith Industries' situation, but to harm the current employer, that's when it's potentially an intentional interference with business relationship situation. Okay, so let's talk about public policy. This is not a very fruitful area in Texas to make a claim. Other states have more generous public policy protections. But the idea here, at least we have some with Sabine Pilot, whether this is a useful thing to talk about. The idea here is that when we talk about public policy is that there are certain things each culture says, we don't think that's right. And it is culturally bound. So there would have been things that our culture in, 1925 would have said, that's perfectly fine. Or, well, we don't like it, but we certainly don't think there ought to be a ban on it. That today we would look at and go, oh no, that's really bad. We don't want that to have happen, and vice versa. So the mores, the values of the culture evolve over time, change in certain respects, and so public policy is attempting to say this is how the significant majority of people in this jurisdiction feel about this particular issue. Now, there's no formal polling that happens. This is, again, judge-made law, so it's kind of a seat of the pants thing. Now, one thing I want to distinguish is that public policy considerations do arise, obviously, when the legislature passes statutes. But instead of considering public policy in that situation, we just look to the statute because the statute should enshrine whatever the public policy is. After all, the legislators and the governor are elected. And so uh, they are the representatives of the public, and so they are speaking what the public policy is. Judges in Texas are also elected, but their role isn't kind of as much that democratic representation role. Their goal is justice. So we talk about public policy primarily when we're talking about the common law. And some jurisdictions have a much more active court system with respect to identifying public policy concerns. Now, we can imagine, not hard to imagine at all, that an employer might sometimes want its employees to do things that aren't good for the culture at large. For example, an employer might want an employee to break a law, or might want an employee to do things that will harm the environment, or do things that are unfair to its customers. And so the question is, well, which one of those behaviors are so bad that we're going to stop the employer from being able to do that? Because there's always things, I mean, we can all say, probably swearing is a bad thing, right? We all probably think, yeah, in theory, people shouldn't swear. But we all probably agree there shouldn't be a law that stops people from swearing. It's not a good thing to do, but it's not something we ought to legislate or we ought to forbid. So some things are in that gray area. We might all agree, oh, yeah, employers shouldn't do that, but we might not think that the state should stop the employers from doing that. And so you have situations where that's good behavior. We applaud the employer for doing that. Then there's other behavior we say, no, we're not going to let the employer do that. And then there's stuff in the middle that we may say, we don't like it, but we're going to let the employer do it anyway. So that gray area is kind of where the public policy exceptions can grow. And this is how you would approach this if you are a plaintiff. To have a public policy exception to at-will employment, the plaintiff would have to show that there is a clear public policy that existed relevant to whatever that conduct is that resulted in the plaintiff's dismissal, that discouraging the conduct in which they engaged would undermine this public policy, and that engaging in conduct supportive of public policy resulted in the termination. So these are the three elements. Now, some states, again, are going to put several things in this category. You probably recall, though, that Texas isn't one of those. Here are four that are commonly done. One is if an employer wants an employee to commit an illegal act, and the employee says, nope, not going to do that, and the employer fires him because he refused to commit an illegal act, that seems like a pretty clear case of public policy. And sounds like a pretty good time we want to have a public policy exception to employment at will. Another could be exercising a legal right. The employee is doing something that he or she has a legal right to do. The employer fires the employee for doing that, or for performing a public duty like voting, or for reporting illegal activities such as whistleblowing. Of these four categories, we only have the first one in Texas covered as a common law public policy exception to employment at will. Now, obviously, we have statutory protections for some things in these areas, but they're specific to whatever that particular issue is. There isn't an overarching concept. So you really have to go into and say, well, what is the legal right? Well, what's the statute that talks about that legal right? Well, let's see if the statute provides that the employer can't fire for the employee exercising that particular right. So it's going to be a pretty narrowly crafted exception under those circumstances. So this takes us to Sabine Pilot. That's what we call it in Texas. It's a Texas Supreme Court case from 1985, and it created a very, very small exception to employment at will in Texas. And this is the exception. An employee has a cause of action against an employer if the employer terminates an employee solely for refusing to perform an illegal act. So let's unpack this. So first of all, it has to be an illegal act. It can't be just an immoral act or an unwise act or an unkind act. It has to be illegal. You have to be able to point to a law that that act would have violated. Another thing that has to happen is the employee has to refuse to do it. And so, if the employee actually does it, there's obviously not a situation where Sabine Pilot would apply. Or if the employee was thinking about whether he was going to do it and the employer goes ahead and fires him before he's actually refused, you also aren't in Sabine Pilot territory. Then the final one is final requirement is that it has to be solely for this reason. So let's say that the employee refuses to do X illegal act, and also the employee had an attendance problem. The employer says we're firing you for both reasons. Well, it's not solely because of the illegal act now. And so would be a lawful termination in the state of Texas. So it's a very, very narrow exception. And the court has had opportunity, the Supreme Court has had opportunities to expand that protection and has chosen not to. Let me show you the Sabine pilot case. I think I've probably posted it elsewhere, but this is the decision. It's a good one to look at, read at your leisure. It's not a long case. Actually, it's a quite short case. This is a concurring opinion. So the actual opinion is just that long. So not a very long opinion. Obviously, the justices on the court are different now, but I think that the current configuration of the court has had the opportunity to expand it and has chosen not to. So I think this is the law as it currently exists in Texas. Again, tomorrow, who knows? We've already discussed whistleblower protections. There's a federal law for federal government employees called the Whistleblower Protection Act. Again, would apply in Texas because obviously there are federal government employees here, but not an area that you're very likely to experience actual issues arising in your role as a counselor to employers or employees. The False Claims Act. Here, let me go ahead and recommend that you add this to your Quizlet. And here's the definition. It applies to those who report a knowingly false or fraudulent claim made against the federal government. This name of this act throws people because it's kind of the reverse of what you think it is, because it's a claim about false claims. So the false claim is not the plaintiff who's filing the claim. So what the plaintiff files a claim. So the way that it starts is employer submit some kind of fraudulent paperwork to the federal government. Oftentimes this is pursuant to a contract or whatever. Maybe is seeking reimbursement for expenses that hadn't actually been incurred. One of the employees of the employer, perhaps the person who processed it or at least was aware of it, realizes that this is a false claim that its employer has submitted to the government. So now it wants to report that claim to the government so that the government can recoup the money from the employer. The Department of Justice, which obviously represents the U.S. government, can join into that suit. And again, the individuals, the employee can also sue. But of course, in this situation, the employee hasn't been harmed by the employer's actions. The entity that's been harmed is the U.S. government. So the employee suing under the False Claims Act is actually suing on behalf of the U.S. government. The employee is stepping in and saying, look, the U.S. government has been forced to pay money that it shouldn't have, and so I'm going to file this suit on behalf of the U.S. government. Now, let's say the lawsuit is successful. Well, the money goes to the U.S. government because, after all, the U.S. government's the entity that is, out the money. But the employee gets a finder's fee, 15 to 30% of whatever the recovery is. It's kind of like a bounty. And the reason for the bounty is to motivate employees of the employer who are in a position to know about the false claim to motivate them to report it, because they can say, let's say it was $100,000. Well, the employee says, my employer got extra $100,000 from the U.S. government. I may get $15,000 to $30,000 if I can prove that the employer actually should not have gotten that $100,000. And so that's motivation for the employee under those circumstances. And let's talk about civic duty laws. These are laws that are designed to protect employees as they perform civic duties. And Texas, and I think probably virtually every state, has something like this about voting. So you have the right to vote, assuming you're eligible to vote, if your employer can't deny that right to you. Let me show you the statute that we have in Texas in this area. Here, jurors' right to reemployment. An employer may not discharge, threaten to discharge, intimidate, or coerce any permanent employee because the employee serves as a juror, or for the was I say voting? I was talking about jurors. Sorry about that. Or for the employee's attendance or scheduled attendance in connection with the service at any court in the United States. We do have a right to vote too. I'm sorry, my brain wasn't clicking there. So if you are called for jury duty, obviously you have to serve, and the employer can't fire you for that reason. The employer doesn't have to pay you for that time, although many employers will. USERRA is a similar law in terms of protecting employees' rights to perform their civic duties. And that would be civic duty in the military. Again, the USERRA grants extensive reinstatement rights and some protection from firing for employees who have served or are serving in the military. Again, I talk about that in the FMLA module. USERRA is not part of the FMLA, but it fits nicely with the military part of FMLA, so I've included in that module. As a general rule, employees can file charges, give testimony, take other actions involved with enforcing all of the discrimination laws that we've talked about. So, Title VII protects oppositional conduct, oppositional activity. ADEA does, ADA does, the Texas statutes in these areas do. Statutes prohibit terminations with the purpose of restraining an employee from exercising his or her statutory rights. The Family Medical Leave Act is an example of that. So if my employer fires me because my employer knows I'm about to go on an FMLA leave, then they have restrained my right to exercise, restrained my ability to exercise my rights under the FMLA, and that would be a violation of FMLA. Talked about off-duty conduct laws. Texas does not have one of those laws at this time. We've talked about disparate treatment, so I'm not going to spend time talking about this except to point out this is that prima facie case that we've talked about so many times. This is the equation that we get from McDonnell-Douglas case. So if you've forgotten it, you may want to look at this slide a little bit more. And this is the topic of comparators. Courts and juries like to see comparators. So if let's say I am a woman and I was discharged for my attendance, and I had a coworker who did essentially the same things at work that I did, the same position, in other words, and he's a male. And let's say he had poor attendance, but he was retained. That would be an example of a comparator that would help me out. But let's say there was another male in the department who had attendance about like mine, and he was dismissed. Well, that would be a comparator that would help the employer out. So ideally, you want to have the comparisons as close as possible, in terms of job responsibilities and in terms of whatever happened, what the facts of the situation are. And this goes back to that idea that if the employer is being consistent, then the comparators are all going to line up and they're all going to help the employer's argument, or at least that's going to happen the vast majority of time. And that makes it very, very difficult for a plaintiff to be successful. So you want to have that consistency, those standards of conduct, and you want to advise your clients, kind of one of the first questions you ask when they come to you saying, well, we want to take a disciplinary action against that Bob or Susan or whatever, is to say, what have you done in the past in similar circumstances? And smart employers actually keep logs of this where they can show, oh, yeah, 4 years ago this happened. Because the reality is there's turnover in personnel, people forget cases. If you work in HR, you're involved in so many dismissals in a large organization, there's just no way you can remember all the names and the dates and the circumstances. So having some system that, maybe keywords that you codify, it can be very helpful. You can kind of pull that information up and make sure that you are being consistent. At this time, we're going to end this lecture. In our next lecture, we'll discuss just cause and the due process system, and also how to handle the termination when you've decided that's something that needs to happen. I thank you for your attention. If you have any questions, as always, feel free to pop into my office hours. I hope you have a wonderful day.